The Criminal Code Act 1995 is a Commonwealth Act. That means it's a piece of Commonwealth legislation. It applies to all Australian states and territories, and it covers an extremely broad range of offences. Anything from theft, fraud and dishonesty, to computer, carriage service and postal offences, drug possession, manufacture, supply, importation, people smuggling, child trafficking, slavery, sexual servitude. It's a whole range of offences. There's robbery, kidnapping, rape, torture, murder, the whole gamut of offences, all the way up to things like war crimes and crimes against humanity. Sometimes the history of a piece of legislation can put into perspective why the different parts of that legislation, the different offences for example, are included, and why it's so big or why it's expanded and how it's all come about. So here's a brief history of the Criminal Code Act. In 1987 there was a review of Commonwealth criminal law. So the government got together and in their wisdom they said that rather than having all these different pieces of legislation, let's try and get it all together into one single code. And the initial aim actually was that this code, the Criminal Code Act, would supersede, so it would override, it would take over state and territory legislation. So it would cover all of Australia. That never really occurred. So nowadays there's a substantial overlap between state legislation, for example New South Wales laws on criminal activity, and the Criminal Code Act. That means that the same offences are included quite often in both acts. In 1992, the final report of that committee was delivered, and in 1995, the Criminal Code Act was created. And that actually, in many respects, took over or superseded the Crimes Act in 1914 as the main piece of Commonwealth criminal legislation. On the 1st of January 1997, the code commenced operation, and it initially contained a range of offences, but that's increased massively over the years. Perhaps most significantly in 2005, when drug importation offences came over from the Customs Act to the Criminal Code Act. Other parts also came in, for example, people trafficking and a range of other things to create the act that we have now, which is, quite frankly, massive and again covers a very, very wide range of activity. Commonwealth cases are different to state offences in many significant respects. For example, the different elements or ingredients that are required to be proved by the prosecution in Commonwealth offences may be quite different from those that need to be proved in state offences, even similar state offences. And this applies to a range of offences, including drug offences, sexual offences, violent offences, fraud and dishonesty offences. So, for example, a drug case may require the Commonwealth to prove A, B and C. But for a similar drug case, the state legislation may require different things to be proved, and it's very important for your lawyer to know what needs to be proved in your case so that they can fight for the withdrawal of the case. Now, there can be different rules that apply to procedures such as searches, warrants and arrests. And again, your lawyer must be experienced in Commonwealth cases, familiar with Commonwealth cases, so they know what rules apply in these types of cases, because then they can push hard to get a case dropped on the basis that the rules weren't followed. There are different rules about which cases stay in the local court and which ones go up to the district court. Quite often clients come to me or to one of my senior lawyers and they say that their lawyer advised them that their case could not remain in the local court, when the rules are quite clear that it can remain in the local court, and their lawyer should be pushing for the case to remain in the local court. There can be different policies and guidelines that apply to the prosecution withdrawing cases. That is, the Commonwealth DPP are a separate and distinct body that prosecute Commonwealth offences, and they have different rules when it comes to withdrawing cases. So your lawyer must be familiar with those rules so they can push better for cases to be dropped or withdrawn. There are different considerations when it comes to sentencing. That is, different rules apply if you plead guilty and you're being sentenced in court. An experienced lawyer will quickly be able to detect these problems and will be able to push hard for the withdrawal of case, or push hard for the reduction in the seriousness and the number of the charges. So you should look for a lawyer with a good track record of winning Commonwealth cases in court, and if the evidence is strong, of getting charges reduced to less serious charges, keeping cases in the local court where there are lower penalties, and obtaining the most lenient penalties in Commonwealth cases, including often avoiding criminal convictions altogether.